Okay, perfect. So everyone's being recorded now. Welcome everybody. So today we're going to go over chapters 13 and 14 of business law. In particular, we're going to go over the introduction to contracts. So let's begin that. I'm going to start sharing my screen to the textbook and we can continue to move forward. So let me just do that. Okay. Okay. So here we go, guys. So we're going to go over the key terms for chapter 13. This is an introduction to contracts. So what a contract is, what are the contents of a contract, etc. So let's begin. So we have what a contract is. So it's just a promise or set of promises for a breach of which law gives remedy or performance of which the law in some way recognizes as a duty. So let's say, for example, Christian, for example, let's say we do a contract to supply you with my phone, right? Let's say I say, Christian, I'm going to supply you with 50 iPhones a month for you to sell. Let's say I'm Apple and you're a retail store, and I give you permission to do that. We would enter into a contract. So by this, let's say I am not able to deliver the phones, or I don't deliver you the phones because we sign a contract. You can press legal charges against me if I do not fulfill my contract. So the reason why it's done that way, businesses can conduct business ethically and to make sure everything is done properly and that all promises are enforced. That way, where the businesses can grow together and be more profitable as a result. So that's why we have contracts to begin with. Um, so that's just a basic overview of a contract. It's just a legal prompt. It's a legal obligation to fulfill a promise or a legal obligation to fulfill a promise and to do something. And that's the difference between a unilateral contract and a bilateral contract, which I'll get into later. So a certain type of contract between an employer and an employee would be a covenant. So hold on, give me 1 second. Trying to join my meeting. Submit. Good. Okay, so we would have a covenant not to compete. So, for example, let's say I run a business that has a revolutionary software, and I hire a team of 3 software engineers to help maintain my software and make sure that it's running properly. Let's say I have a cutting edge AI software that can be used for any business in the country. Legally, I with my employees in their employment contract, I can go ahead and say, hey, you cannot take any of my software or any of my clients in order to promote your own business. I can make them sign a covenant not to compete in their employment contract with me. So that would be an example of that. Also, it could happen with a business acquisition. So let's say, for example, Jaden, let's say you sell me your jewelry business in Boca Raton, right? Let's say in the sales contract. So with a business acquisition, where a person buys a business or a business buys another business, you'll have something called a LOI or a purchase agreement. So in the purchase agreement, I can put in a covenant not to compete, stating, hey, for this X amount of time, let's say for the next 3 years, you cannot open up a jewelry store within 10 miles. So that would be another example in the real world of a covenant not to compete. So it's primarily used in employment, but it can also be used in competition in business, in particular with the business acquisition occurring with a well-established company. Okay. So then we also have an agreement. So you guys need to know the difference between an agreement and an acceptance. So an agreement, like for example, let's say Victoria, we come to an agreement. Okay, you're gonna attend the rest of my group sessions this week. So that's an agreement that we come to. But let's say you don't agree to that. So an agreement is going to consist of an offer. So let's say, hey, I will give you X amount of items in exchange for X amount of dollars. So that's an agreement that contains an offer, meaning, hey, to give this in exchange for this amount of compensation. Until you, meaning we agree to the terms and we have an acceptance of the agreement, we don't have a contract. So an agreement is basically an offer. One party agrees to give an offer. The acceptance is with both parties accept the offer and enter into a contract. So an agreement is before the offer is accepted. The acceptance is after the offer is agreed upon by both parties. So that's the difference between an agreement and an acceptance. Okay. And then we also have consideration. So that's basically what is being given in exchange for the contract. So in order for a contract to be reasonable, both parties have to benefit in some way. There has to be an exchange of value, whether that be of goods, services, materials, data, etc. That is what consideration is. So each party has to gain something from the contract. So let's say we did a sales contract for a piece of commercial real estate. The seller selling the property would receive some type of financial compensation. The person who is buying the property would receive rights to use the property, to rent it out, or to occupy for their business, and also to make renovations to the property, unless if otherwise stated in the sales contract. So those two parties making an exchange that benefits them would be a consideration. Okay, perfect. Okay. Okay. So let's go here. We also have contractual capacity. So we already went over the first two parts of a contract. We need to have an agreement, which is an offer. The parties need to enter an acceptance, which means both parties agree to the offer. There needs to be consideration, meaning there has to be some type of fair exchange between both parties. And then we have contractual capacity. So let's say, for example, I sign a contract with Mr. Gendler, Professor Gendler, stating that I'm going to loan his law firm $150,000, but he has to pay me 30% interest. Let's say Professor Gendler is mentally unstable. Let's say he has some type of mental disorder that impairs his ability to understand terms of the contract. That contract is unenforceable because of his lack of contractual capacity. So he can't understand the agreement, therefore he can't enter into it. So some of the terms that prohibit people from entering contracts due to a lack of contractual capacity are minors, so people under the age of 18, people suffering from mental illness, as I just explained, intoxicated persons. Now, there are certain aspects of being intoxicated. You have to be intoxicated to the point where you cannot understand the terms of the contract and what you're agreeing to. If you can argue that, you can argue that you didn't have the contractual capacity. However, just because you might have had a drink or two, that doesn't necessarily entitle you to be protected under contractual capacity. So those are the main three. Not being age of majority, people suffering from some type of mental illness that affects their capacity to understand the terms of a contract, and then people who are so intoxicated that they can't understand. So those are the three examples of not being able to fulfill contractual capacity when entering into a contract. So the next defense that you might be able to have is a lack of genuine assent. So let's say, for example, we have duress, undue influence, and misrepresentation or fraud. So let's say, for example, in a contract, let's say, Anna, for example, we entered a contract for you to give me title to your condo, right? But let's say you didn't agree, but I forged your signature on the document. You could argue a lack of genuine assent, saying, hey, Jared forged my signature to give my title over for my condo, and I don't want to enter into this contract. So let's say we both did that, or let's say I did something else. Let's say we agreed that, let's say, for example, I agreed to sublease your condo as an Airbnb, but let's say I let the people in the Airbnb make a renovation to the condo. Let's say you didn't agree to that. That could also be lack of genuine assent. Even though we agreed, I did something that wasn't agreed upon. That would fall under misrepresentation. We could also have duress. So we remember what duress is. It's just basically threatening someone with a worse action if we don't do a certain action. So let's say, for example, I say, I'm going to damage the condo as collateral if you don't make the rent payment. That would be under duress. And then undue influence means You're basically having an outside party trying to influence you to make a decision you wouldn't normally make. So let's say, for example, there's a lot of pressure from one company. One second. So let's say, for example, we have a will case, right? Let's say we have three siblings, and one of the siblings is trying to pressures the mother to say, "Hey, put me as the only beneficiary on the will. Exclude my two other siblings." And let's say, you know what? If you don't do that, I'm never going to talk to you again. That would be undue influence. So a lack of genuine assent means that even though the contract was agreed upon by both parties, the way it was done is against the law or not ethical. So that's what lack of genuine assent is. Okay. And then we have the UCC, Uniform Commercial Code. So we also have the UCC, which is the Universal Uniform Commercial Code. So all this is just a set of common law that regulates business and commerce within the United. All right, a lot of people joining this. Okay. Okay. Perfect. Okay. All right. So that's what the UCC is. It's just a guideline in order for businesses to follow. Each state has their own UCC. Now, we have two different types of contracts. We have a bilateral contract and we have a unilateral contract. So let's say, for example, Victoria, we enter a contract to sell me, I don't know, let's say you're going to sell my retail store baby powder. That's the first thing I saw on my desk. Let's say you're going to sell me 1,000 units of baby powder a month in exchange for 30. In exchange, I'm going to pay $1,000 a pallet. That's a bilateral contract because we enter a promise for a promise. So you promise me to supply me with this baby powder for me to sell, and I promise to pay you a certain X amount of money for the baby powder for the inventory. So that would be a bilateral contract. A unilateral contract is a promise plus a requested action. So the most common one we see is with rewards, right? You guys ever seen an ad online saying, "Hey, my dog is missing. It's a $1,000 reward if you can find them." That would be a promise plus a requested action because the other person is not promising that they're going to find the dog, but they're just making an offer to do so. So that would be a unilateral contract. So one of the party that where the dog is lost say, "Hey, I promise to give you $1,000 if you find my dog." That's a promise plus a requested action. That's a unilateral contract. The other party doesn't have to have a promise to fulfill that. So a bilateral contract is when both parties make a promise, typically an exchange of money or some type of data or value for another source of value. That could be inventory, employees, money, etc. Where both parties promise to come to an acceptance of terms that make sense and will benefit both of them. And a unilateral contract is a promise. So say, "Hey, I'm going to give you this amount of compensation if you can even find my dog." That's going to be a promise plus a requested action because the other party doesn't have to fulfill that, is not legally required to fulfill that promise. So that's a unilateral contract. So that's the best way I can describe the differences between the two. Okay. Okay. And we also have a unilateral contract. And then we also have an express contract. So that's a contract that's going to be clearly set forth in written or spoken words. So let's say, for example, I enter into a contract with a dentist stating that I can't sue for any medical damages. Let's say I enter into that. Or a better example would actually be, you guys ever been to a trampoline park and they make you sign a waiver? That would be an example of an express contract because that is a contract between you, the customer, and the business stating if you get injured, you cannot sue, and you sign that before entering. So that would be an express contract because it's clearly set forth in written or spoken words. So that would be an express contract. Now we also have an implied contract. So for example, in an implied contract, let's say you get your nails done at a spa, for example. The person doing your nails has an implied contract in order to touch your hand in order to complete the service. That would be an implied contract. Or better yet, let's say, for example, we enter into an emergency room to get service. It's an implied contract that we're going to have to pay some type of medical bill in order to create a fair exchange between both parties. So that would be two examples of an implied contract. And then we also have a quasi contract. So it's not really a contract, but it's rather, it prevents one party from being unjustly enriched at the expense of another. So this typically happens when someone does work for somebody that was not wanted. This is very common. Let's say I actually had somewhat of an incident like this in my house. So around 10 years ago, 11 years ago. So the weird thing about my house is that there's two of the same addresses in the same town. So I grew up in a town called Merrick. There's two of my same address in my town. So I guess the person at the other address, they were redoing their driveway and they requested to have a bunch of dirt dumped on there. That way they could redo it with a patio and whatnot. And the person that was doing that, the paving contractor, they wound up dumping all of the dirt on my parents' front. And as a result, we obviously didn't have to pay. But let's say, for example, they did charge us to dump that. That would not be allowed because that's a quasi contract because we did not ask to get dirt dumped onto our driveway. So that would be a quasi contract. If the company still wanted to charge us for that, they couldn't do it because of a quasi contract. And the reason for that is because it's unjust. We didn't agree to that, but they want to charge us anyway. That's unjust, and it's going to fall under it. So these are the statuses of contracts now. We have valid, void, voidable, and unenforceable. So a valid contract means that all the legal elements are going to be set forth, right? So typically a valid contract is going to be one that's going to be enforced. So if we have all of the legal elements are right, all the material terms are right, that contract is going to be valid. Now let's say the contract is valid, but there is a clause in there that is illegal. Let's say, for example, we'll give you a kickback or a bribe for every client you bring. Or let's say we do that, for example. Let's say in our business, let's say we have a government related business that's illegal. That would make the contract unenforceable, even though everything is valid and both parties came to an acceptance, because we have a law that prohibits us from enforcing the contract. So unenforceable is just when there is a law preventing the contract from being legal. That's all unenforceable is. Now we also have a void contract. So it's basically when there's no contract at all. So let's say the court finds out that it's unenforceable. There's something in the contract that is illegal or not allowed. The contract becomes void. It's done. That means there's no contract at all. If you guys ever written a check and you had, let's say you messed up something on the check, you write void on the check, meaning it is not a check anymore. It's the same thing with a contract. And then a contract can also be voidable. So let's say I enter into a contract with a company that's going to supply my retail store with baby powder. Let's say I say, hey, if my baby powder is not selling, I can make the contract voidable. So let's say we agree to that and we come into an acceptance, the contract can be voidable. So let's say the baby powder sales are not profitable. I could tell the company that's supplying it, hey, I don't want to pay anymore. Here's all the inventory back. I want to void. So that would be an example of a contract being voidable. But let's say I did that without the party's consent, or let's say I did that fraudulently with misrepresentation, then the contract might not be allowed to be voidable. So that would be a clause that could possibly prevent that. But if both parties agreed fairly without any duress, undue influence, misrepresentation, or fraud, contract can be voidable as long as everything is fair in regarding that. So we have two different types of statuses of contract. We have when a contract's executed, which means all the duties in the contract have been fully performed. So let's go back to the baby powder example. Let's say we fulfill the contract. Let's say we agreed 6 months. You're going to supply me with 10,000 units a month, and I'll pay you X amount of dollars. Let's say you've supplied me with the units over the term of the contract. I've paid you all the money on time and in full. That contract's been executed. It's complete. But let's say we're in month 4 of 6 of our contract. Then the contract's executory, meaning that all the obligations have not been completed yet. So once everything is complete, all the payments are made, all the inventory is delivered, the contract is now executory. It's executed, excuse me. And then once the obligations haven't all been fulfilled, it's executory. Mm-hmm. So think of executed like when someone is executed, means they no longer have life. And executory, try to think of it as the opposite, meaning that they're about to be executed, but they haven't been yet due to court or trial or being on death row. That's how I try to think of it, at least. So we have two different types of contracts. We have a formal contract and then an informal contract. So a formal contract means that the contract was agreed upon verbally or in writing. So an example of a formal contract would be an express contract. So there's four different ways a contract become formal. Number one, the contract will be under seal. So let's say we enter into a contract. Let's say our attorneys put some type of wax. It's known as locus sigilli, which means the place for the seal at the end. This means that the contract is valid and that we've agreed to a formal contract. So that's the first way a contract can be formalized. The second way is through a recognizance. So in the contract, when we sign a contract, both parties recognize and understand, because the definition of recognizance is when both parties understand that if the terms of the contract are not fulfilled, legal action can be taken against the party. So that would be how so when the parties go to court to enforce the contract, both parties are going to agree, which is a recognizance, that if they fail to fulfill the contract, they must pay some type of price or have to go to court in order to settle. So that would be a recognizance, meaning they're legally bound and understand that they are legally bound to have some type of penalty if they do not fulfill the contract. And then we also have a letter of credit. So this typically with invoices and fulfilling accounts receivable. So let's say I own a construction business and let's say my subcontractor, we enter into a letter of credit. I send them an invoice stating in 30 days after the job is completed, I'm requesting my payment. So we would do a letter of credit in order to ensure that we receive our money, meaning that the subcontractor is legally obligated to pay us at the end of the job completion. So that would be an example of a letter of credit. It would basically be an invoice and receipt of what we did in order to make the other party legally bound to pay us. And then we also have negotiable instruments. So those are just unconditional written promises to pay us a certain type of money on demand or on time. So that could be a check, note, draft, a certificate of deposit, etc. So let's say I enter a certificate of deposit with TD Bank. Let's say they agree to pay me 4% on my money every year. That's a negotiable instrument. The certificate of deposit, let's say I put $10,000 in there and I will receive a 4% APY. So we enter an agreement that I'm going to receive at least $400 in interest on my certificate of deposit that year. And then we have an informal contract. So these are really complicated because it's very disputed whether there's an actual contract or not. It's very controversial, like I said. So it's basically there's not going to be a formality in making them. There's no written signature. There's no verbal agreement. It's just basically a promise out in the air, and it's hard to enforce. One, very difficult to enforce. But it's basically just going to be a contract that's not formally set out in words or in writing. So that's what an informal contract would be necessarily. So the difference between this and this, formal is going to have a negotiable instrument, a recognizance in court, a letter of credit, or a contract under seal. So an invoice, a contract that's sealed in wax, a recognizance, meaning both parties can go to court if the contract's not fulfilled, and then the informal, they wouldn't have any of those any of those instruments whatsoever. And then we also have the plain meaning rule. So all this means is that, let's say we enter a contract, we must view all the terms in the contract literally. So when we see a certain clause in the contract or an agreement that's in the contract and the offer, we have to view that offer in literal terms. That's all the plain meaning rule is. Okay, so that is chapter 13 complete. I'm going to move on to chapter 14. Okay, so now we're going to get more into the offer. So what the offer is, the elements of the offer, etc. So we have two different types of people in an offer. We have the offerer. So let's say I offer to sell 1,000 units of baby powder a month through Walmart. So I'm the offerer and Walmart is the offeree. So in order to make this offer reasonable, we have to meet three criteria. Number one, we have to have serious intent by the offerer to be bound by the agreement. So that means I have to intend, no matter what, to make sure Walmart gets 1,000 of these a month. So that's going to be serious intent. I'm going to be bound to that because if I don't, I'm not going to be able to fulfill the contract. Number two is going to be reasonably definite terms. So if my terms are unreasonable, let's say I say, you know what, pay me $2 million a month for 1,000 of these. That's not going to be reasonably definite terms because of the value of the inventory. So you need to be able to fulfill reasonably definite terms in which both parties agree to. And then number three is some type of communication to the offeree. That could be through email, through mail, through a formal contract. In order for an offer to be valid and be able to be fulfilled, I have to communicate in some way to the offeree. I can't just enter a contract randomly with a company that I did not express to them that I wanted to get them a contract first, if that makes sense. I have to clearly communicate my offer to them. So the first element that we have is intent. So means that we have to be bound by the offeree's acceptance. So that means, let's go back to the Walmart, for example. Let's say they don't want my baby powder. Let's say they don't think they can sell it. I can't send a shipment of baby powder to Walmart anyways, because that would violate intent because the offeree did not accept my offer. So that would be an example of intent, allowing for a contract to not be enforced. So we also have preliminary negotiations. So let's say I ask, let me take a look in here. Let's say I ask Eva, I'm interested in your car. Do you think it's possible you could sell it to me for $10,000? So that is not making an offer. That I'm just asking you about your willingness to sell. I'm not saying, hey, I have $10,000. I want to put $10,000 to buy the car right now. That would be an offer. But if I'm inquiring, say, hey, is this for sale? That's not an offer necessarily. It's an invitation to enter into an offer. So you can have an invitation to negotiate or to bargain for a exchange. So that's going to be a preliminary negotiation. It's just basically an invitation to negotiate or an expression of possible interest. And you'll see how this is important with certain types of advertisements. That's later in the chapter. And then you'll see right here. So let's say I invite people to come into the store because I'm doing a promotional sale. That's not an offer necessarily. It's just an invitation to come in and make an offer. Okay. And then we have the terms in the contract. So the terms of an offer have to be definite and certain. So all the material terms have to be included. So how much, let's say we go back to the baby powder, how much baby powder we're going to receive, how much we're going to receive in compensation for the baby powder. That could also be the quality that they have to meet. And we want to make sure, I don't know if you guys remember, but Johnson & Johnson sold baby powder that caused ovarian cancer. It was a huge lawsuit. So we would have to come to terms with the quality of the baby powder. We got to make sure that the containers are not damaged, that the baby powder has no defects. That way, none of the people who buy it get injured. So those are going to be the material terms. So that's going to be the matter, price, quantity, quality, and parties. So maybe we enter into a contract saying, hey, we want you only selling baby powder to us. You can't sell this baby powder anywhere else. Let's say we agree to that. That's another example of a material term. And then we have communication. So it has to either be communicated to the offeree or the offeree's agent. So let's say we have a minor, for example, let's say a child actor like Miranda Cosgrove, right? She likely entered a contract with Nickelodeon in order to receive some type of compensation for acting in iCarly. But because at the time she was a minor, due to the fact that she was a minor, she might not be able to consent to that contract. So Miranda Cosgrove likely had an agent or some type of parent or guardian, but probably an agent that would agree to contracts for her. So that agent would be acting on her behalf. So Nickelodeon or whoever produced the show iCarly would be communicating the offer to the offeree's agent, Miranda Cosgrove's agent. Okay, and then we have termination. So there's different types of ways an offer can be terminated. A terminated offer means that the offer no longer exists. We can't enforce that no matter what. So there's different type of ways that we can terminate an offer. So we have revocation, rejection, counteroffer, death or incapacity, destruction or subsequent illegality, a lapse or kind of failure as well. So I'm going to go into each one and explain which each one is an example for every single type of termination. So revocation means that the offer is revoked. So let's say, for example, we enter into an option contract, which I'll explain a little later. Basically, an option contract means, here, I'll give you guys an example. So let's say I'm an actor, and I agree to be paid, let's say the offerer, let's say Nickelodeon agrees to pay me $2 million to act in a season of this show. Let's say I want more money. Let's say I want 2.5 million. Well, that would be a counter offer. But let's say in there, they'll say, hey, we will give you 30 days to make a decision on if you're willing to accept this compensation. So let's say in the 30 days, I agree to it, we would be all right. But let's say we do revocation. So let's say I make a decision in the option contract to say I want to decline this offer. That would be revocation. So if I entered into that with the ability to, let's say we agreed to it, and in the contract we were able to void it, and I revoked it, that contract would no longer be valid. Okay. And then we also have rejection. So let's say I just say, you know what? I don't agree to that. That's going to be rejection. Pretty self-explanatory. And then we also have a counter offer. So let's say they offer me $2 million, say, hey, that's not bad, but how about I get 2.8 million? That would be a counter offer, meaning that offer that they made is now terminated. They also have death or incapacity. So let's say I die when we're negotiating the contract. They can't pay me the money anymore because I no longer exist. And let's say the offer is illegal. So let's say they want to pay me the $2.8 million, but let's say they received the money from illegal means. Let's say they did it in embezzlement. Let's say they took investor money and used it to pay my salary for the job. That would fall under illegality. So our contract would not be valid because the money was embezzled. And then we also have a lapse of time. So let's say we entered into an option contract, and after 30 days, I don't make a decision. The offer is now void because of a lapse of time. Okay, and then we have an option contract. So that means the offeree gives the offer a piece of consideration in exchange for holding the offer open. So let's say, for example, I want to, one second. So let's say I want to purchase a subscription, right? So you guys ever seen like, hey, 14-day free trial, right? So we'll let you use the subscription for 14 days and you can cancel at any time before the 14 days. You're entering into an option contract there. So they're giving you a piece of consideration, which is the use of the website and the subscription in exchange for holding the offer open for a specified period of time, which would be 14 days. So let's say you decide to cancel, the company that gave you the membership or the subscription no longer can bill you for using the subscription. So that would be an example of an option contract. Okay, we went over rejection, counteroffer. Okay, acceptance. We already did that. So there's two ways that we can manifest intent to enter into a contract. So by performance or by a return promise. So that goes back to our bilateral and unilateral contracts. So let's say, for example, you go back to the dog example. Let's say Lee offers $500 to return a lost dog. Let's say they offered $500 for someone to find their dog. No one is legally bound to that because it's a unilateral contract. And as we remember, a unilateral contract is a promise plus performance. But let's say, hey, I'm going to give you $500. In exchange for that, you're going to search for my dog, and I'll pay you $500 to search for us. So that would be a bilateral contract, and we are legally bound to that. Okay. And let's say we also have silence. So let's say I agree to, let's say I say, hey, I'm going to pay you $50. I'm going to give you a $50 tip at the end of the shift. And let's say you don't agree to that. Or let's say I'm going to have you work another hour and a half for the remainder of your shifts for the next 2 weeks. And let's say you don't agree to that. You don't say anything. That's not a contract because you have not verbally agreed to it. So we also have a mirror image rule. So all this means, think about it like a mirror. You're seeing your reflection. So it's basically the terms of the acceptance must mirror the terms of the offer. So let's say we make an offer to sell 10,000 of these a month. In exchange, we'll pay the supplier $20,000 a month for the next 6 months. We can't go ahead and say, hey, we're only going to sell 3,000, but we're going to charge 15,000 because that doesn't follow the mirror image rule. So instead of that, the attempted acceptance is going to be a counteroffer. So whatever we agree to. So basically, what we say in the acceptance has to mirror the terms of what we originally offered. If it's not, then it becomes a counteroffer. And then we also have the mailbox rule. So this is a little complex, especially in the digital age where a lot of people are doing e-contracts through DocuSign and items of that nature. So basically how it would be was, let's say I enter the contract for the baby powder, and let's say I sign the contract and I mail it to the office of the supplier. Because of the mailbox rule, that contract is now enforceable as long as it's not illegal or falls under a statute of frauds. So that would be under the mailbox rule. Now, let's say, for example, it's a email, DocuSign. It's going to also fall under the mailbox rule because of the Uniform Electronic Transactions Act. So basically, if you sign it and put it into the mailbox or send it back to the other party, that contract is now entered into an acceptance. Okay. So those are the key terms. I'm going to go over some of the other terms in here that we might not be able to cover. Okay. Let's go back up. Second. Okay, so let's go back here. We did executed versus executory. So, okay, let's go back to void and voidable. So we can have an error in a formation of contract that can make it voidable. So let's say, for example, we're trying to, let's say, for example, we make a contract voidable with a minor, a child actor, and let's say when they turn the age of 18, we can void the contract. Or let's say, hey, let's say we committed some type of fraud in order to void the contract. Let's say we forged their signature. That can make it voidable. So let's keep going up. I just want to try to cover as much as possible for you guys. Okay. Okay, we did quasi, did express versus implied. Okay, we did unilateral, bilateral. Okay, so this is good. And do any of you guys want me to go over something specific? If you want to go over some specific, just let me know now. That way we can go over it one more time.
Can you go over the definite and the certain terms one more time? I didn't catch that.
Certainly. Let's go back to that. All right. Yeah. 354, okay. Okay. So who asked that question, by the way? I'm sorry.
That was me, Jaden.
Okay, Jaden. So let's say, Jaden, you own a small business. Let's say you own a dog grooming business, and let's say I'm your landlord. So we enter into a contract for a lease. Let's say you want to sign a 2-year lease to utilize a 3,000 square foot space in a shopping mall that I own. So let's say I make an offer to you stating, hey, I'll let you use the premises. The charge will be $4,000 a month, first month's and next month's rent as deposit. We have to include the material terms. So we have to go over the price of the rent, how much of the space you can use, and we also have to go over how the space can be used. That will be more in depth in the landlord tenant law. We'll go over that on Thursday or Friday. But we have to make sure the terms are definite and certain. So all the material terms, meaning the matter, so what you can put in there. Let's say, you can't put a meth lab in there. So that would be the matter. The price, meaning how much I'm going to charge you for rent and utilities. Let's say we sign a triple net lease, which all triple net leases, guys, if you don't know, it's just a lease in which the person who is renting pays the utilities for the space. So the price of the initial rent plus any utilities, the quantity, so how much of the space you can use and how long, You can use the space for the quality, meaning what you can do to the space, what type of renovations you can make, what you need to add to it, and then the parties. So whatever parties enter into the lease agreement. So the material terms are those terms, the how the property has to be maintained, the payment of the rent, and who can be in there. And then the definite and certain means that all these terms have to be included into our lease contract, into our lease agreement. So that's all that's meant by when terms are definite and certain. It means all the material terms that can be in there are included in the contract. There's nothing that we can't understand in there. Everything is in the contract. That's all it means. Does that make a little more sense?
Yes, thank you.
Okay, perfect. Does anyone else have anything specific that they want to go over before I start going over some of the other examples in chapter 14? Okay. Okay, so let's continue to go forward. All right, so we have elements. We went over that. Okay. So here's the agreement process. So let's go back to our baby powder, right? So let's say I reach out to Gold Bond, whoever owns Gold Bond. I forget who owns it. Chatham Inc. is the company that owns the Gold Bond brand. Reach out to Chatham Inc. or whoever their supplier is, and I tell them, hey, I want to do a contract. I want to get 5,000 of these baby powder a month to sell in my store. In exchange, I will pay you $15,000 a month for the next 6 months in order to get those units. I know that's a little high, but let's say we agree into that. So I have properly communicated my offer to the offeree. Let's say I'd made a phone call or I sent them an email. That's a proper communication of the offer. So they're aware that the offer exists. So then there's two things that can happen. The offeree is going to communicate to intent to be bound to the terms of the offer to the offerer. So let's say, for example, let's go back to the offeree and the offerer. So the offeree means that, hey, okay, we're going to supply you with this, all right? And we agree to be bound to that. And if you do not receive the payment, or the payment is this X amount of days late, you can go ahead and we can settle it in court, or there's going to be some type of penalty. So that's when the offer communicates to be bound to the terms of the offer by the offerer. And once we agree to that, we agree to any late fees that might happen, or if we agree to mediation or arbitration, the offer has been accepted and a contractual agreement has been formed. Now, let's say they don't agree. Let's say, hey, we can't supply you with 5,000 of these a month, but we can supply you with 2,000 of them. I can either accept that counter offer or reject it. Or let's say, better yet, let's say they don't want to do business with me. Let's say, you know what? We just don't think that our product can sell in your store. Therefore, they're going to reject the offer. And therefore, that's going to mean our offer has been terminated. So we can't form a contract. So that means I can't go and send the guy over there to purchase them anyways. So it means that we're not going to enter into an agreement and have an acceptance to the terms of the offer. So that's the agreement process. We have a proper communication. We have either a counter offer or the original offer being agreed upon, and then the offeree being bound to the terms of the offer by the offerer, and then either an acceptance or a rejection. So that would be the agreement process, just broken down as simple as possible. Okay, and then we also have advertisements. So let's say, for example, we have Pepsi here. So let's take a look here. So we have a guy named John Leonard. He was a plaintiff in a case describing the opening scenario. So he stated that the Pepsi commercial was an offer because it was clear, definite, explicit, and with nothing to negotiation. So they clearly stated that if you got 7 million points, which I'm not quite sure the context of that, you would earn a jet. So that would be an offer, because they're literally saying, hey, there's no it's not a negotiation, but let's say, hey, Instead, if you enter into our contest, or let me think of a better example. Let's forget about Pepsi, right? Let's say you say, hey, you enter our Pepsi store, you can go ahead and get a discount. That might not be an offer necessarily. So sometimes advertisements can be. So if they're guaranteeing something, a promise for a promise. So let's say, hey, you ever heard of buy one, get one free advertisement? That's actually a contract. So if you buy something from the store, you get it free because both parties are now entering a bilateral contract. But let's say, hey, if you come to our store, we're currently offering a discount for a piece of furniture. That is an invitation to make an offer. So that is not a legally binding contract. And then we also have an auction. So we have two different types of auctions. We have an auction with reserve, meaning that the bidder, the person who is holding an auction, the auctioneer, even if someone makes the highest bid, they can agree to not agree to that bid. So let's say, for example, I have an auction for a very valuable ruby that's worth $100,000. But let's say the highest bid that we're getting is 80,000, and let's say the auction is with reserve. That means that I don't have to accept the offer if I believe it's undervalued. Now, let's say we did an auction without reserve for that ruby, and let's say we had the $80,000, we would have to take the $80,000 no matter what. So, because of this, a lot of auctioneers will make sure that their auctions are with reserve as opposed to without reserve. So the difference is without reserve, it means that we don't have to take the highest bid. With reserve, it means we have to. Okay. Okay, so we have all of this covered. I'm going to go over a case real quick and break everything down. Okay. So let's take a look here at I'm going to go up a little bit. I do want to go over a specific case here. Let's go over Lawrence W. Shipley III versus Andrea Vasquez. So let's look at the facts of the case. So it was between two people, between a flower company and then a school district. So let's take a look. So Ms. Vasquez wanted the company to take part in a school fundraiser. So Shipley decided to not continue into the agreement because the lady didn't have an abortion. Okay, so I was pregnant. When you're looking at a case, very important to understand the facts. This is something that's very important. Keep looking. Okay. So with this, there were definite and certain terms. So they agreed to do the fundraiser possibly, and there was a breach of contract. So they made an oral agreement. So let's take a look. So let's say, was there an agreement to take care as long as the daughter was living under Vasquez's roof? So Shipley breached the oral agreement because he did not pay the child support. And because of that, that was because he agreed to do it, that was a breach of contract, informal contract that they made. So that would be an example of, even though there were definite and certain material terms, meaning the amount that was going to be paid and the terms that had to be in order for the children to be taken care of, that's a breach of contract. Okay. All right. So it's around 2:15. So I'm going to wrap things up here. How do you guys feel a little bit better now about the subject matter? Do you guys want me to go over anything one more time? I just want to make sure everyone's okay before Tomorrow we do some of the other chapters. Okay, that seems pretty much it. So everyone who joined the live session today, so give me 1 second. So I just got to take a picture real quick. Everyone's going to receive practice questions from the material we did today. So give me 1 second. Okay, so just got to take a picture on that. Okay. So everyone will receive a free copy. If any of you guys want, I'm also doing individual sessions. So if I didn't cover something that you guys want to find out more about something or get more specific examples, or just make sure that you're good before the test, I would highly recommend signing up with a private session for me. In addition to that, I also have practice questions as well. Later on this week, I'm going to have a very large 150 questions. It's going to be a basically what I have already for the practice questions, but it's going to cover every single chapter. So that's going to be available to you guys as well. So if you guys want to get that, that's all good. Apart from that, that's pretty much it. And for all you guys that want to join, I'll see you at 1:15 tomorrow.
Thank you.
Perfect. All right. Sounds good, guys. Thank you so much. Have a great day.